Thanks very much, Frank. So I've called this presentation Post-Termination Bonus Payments and the Limits of Good Faith. Good faith is in reference to a bit of a novel argument that was made at the trial level in Alberta that's addressed at the Court of Appeal in this decision. So in Stiles and Alberta Investment Management Corporation, an employee was terminated without cause. He had a contract in place which acknowledged that it was possible he could be terminated without cause, and the contract provided for 3 to 6 months' salary in that event. So it was, imposing a provision that ousted common law reasonable notice. So the issue in this case was this employee entitled to a bonus under the employer's long-term incentive plan? So we're all sort of vaguely familiar with the basic notion. The basic principle in awarding damages for wrongful dismissal is that the terminated employee is entitled to compensation for all losses arising from the employer's breach of contract in failing to give proper notice. The damages award should place the employee in the same financial position that he or she would have been in had such notice been given. And that comes from Paquet and Tarago Networks. That was a case from the Ontario Court of Appeal that came out in 2016 in August, also in regards to bonus entitlement post-termination. So courts will, as a general rule, include all compensation and benefits that the employee would have been entitled had they worked out their notice period, had the employer actually allowed them to continue working during that notice period. It's important to remember that you can contract out of the common law with properly drafted employment contract. Just remember that you can't provide for less or fewer entitlements than the Employment Standards Act would allow for. So the long-term incentive plan in the Alberta case, participants were given a grant each year, but it wasn't a grant in the true sense of the word because it wasn't actually paid and it never became payable as such. These grants under the LTIP vested only after 4 years. So for example, if someone sort of accrued or earned a grant in 2010, it would vest and become payable in 2014, earned in 2011, payable in 2015, so on and so forth. Grants would be adjusted each year, up or down, in the future years based on, I think it was some formula, compound total rate of return, et cetera, et cetera. There was a separate annual incentive plan in this case that paid out every year, and that wasn't at issue. So the key terms of this plan, the long-term incentive plan, were that employees had to be actively employed on the date that the grants vested, and vested or unvested entitlements to these grants, quote, may be forfeited upon the date of termination of active employment. So for those of you who sort of follow some employment law cases or maybe read some of our blogs, as mentioned in the previous slide, back in August, the Ontario Court of Appeal did decide 2 cases in regards to post-termination bonus payments. And it is notable that in those cases, the Ontario Court of Appeal found that requiring active employment when a bonus is payable is actually not sufficient to disentitle an employee to damages in respect of those bonuses. So I'll be commenting a bit on the differences between these 3 cases a bit later in the presentation. So the trial decision from the Alberta decision. The trial judge found that the employer had breached what he called, or she called rather, the common law duty of reasonable exercise of discretionary powers. So according to the trial judge, the plain wording of the contract was irrelevant in this case. It was contrary to reasonable expectations of the parties that, someone would forfeit unvested grants when the whole point of a long-term incentive plan is to, incentivize good performance in employees with the notion that, a big payout will be coming sometime in the future. The trial judge said that the employer chose to terminate him, and therefore it was the employer that prevented him from being actively employed. And as such, the employee was entitled to his long-term bonuses. Common law duty of reasonable exercise of discretionary contractual powers is a mouthful. You might be wondering what it is, and it turns out that that's because it doesn't actually exist at common law according to the Court of Appeal in Alberta. Reference is made in these decisions to a case called Bazin from 2014 from the Supreme Court of Canada. In that case, the Supreme Court sort of examined contract law at large and recognized that there's sort of this general organizing principle of good faith, as well as a duty of honesty in contractual performance. These notions had already been sort of recognized and, almost flowed from employment law, which, is contract law, but with some distinctions. For example, in employment law, the duty of honesty and good faith is recognized particularly in the manner of dismissal. And Bazin, was widely viewed as extrapolating this to contract law more generally. The Court of Appeal observed in the Alberta case that, even with this organizing principle of good faith, parties are still entitled to act in their own best interests. This general principle, duty of good faith and honesty, it doesn't extend to the employer's decision to terminate the employee, because this would undermine their right to determine the composition of their own workforce. And really, the duty to act honestly in contractual performance simply sort of states that parties can't lie or otherwise knowingly mislead each other about matters directly linked to contractual performance. It's very narrow, according to the Court of Appeal, and it doesn't, create a duty of loyalty, disclosure. It doesn't, require that an employer or a party, forego an advantage under a contract. The Alberta Court of Appeal also noted that Bazin and good faith relates to contractual performance, not the terms of the contract itself. The Alberta court says that contracts should be enforced according to their terms unless they're unconscionable. So, in this case, the employee's contract and the LTIP wording said that the grants would vest if he stayed employed for 4 years, and he did not stay employed. So the Alberta Court of Appeal, kind of tells us, there's no such duty of honesty in the way that the trial court had described it. But they still go on to sort of briefly describe and sort of, disagree with the two supposed exercises of discretion that the trial judge had identified. This is important, especially in regards to the second point on the slide. So the first area of discretion was allegedly the decision to deny the employee the value of the grants he had received, even though he was not actively employed at the relevant time. Well, the Alberta Court of Appeal says, look at the wording of the contract or of the plan. There was no discretion under the contract. He wasn't actively employed, so there was no grant. Of course, again, the employer could have chosen to forego this contractual advantage, but that's not a discretion in any sense of the word under a contract. The second is the most problematic. So the trial judge actually reviewed the decision to terminate the employee without cause and sort of examined whether the employer had any reasonable reasons for doing so, which sort of, as we all know as a general principle, is really not the way it's done. No reasonable cause for terminating the employee was evident to the trial judge, so the judge ruled that he should get his bonus anyway. The employer, according to the trial judge, had to show some justifiable reason for terminating him and had not done so. So there's no such thing, it's been recognized in case law, there's no near cause. You either sort of make out reasonable cause and you terminate someone without notice or pay in lieu, or you don't, and in which case you either give them reasonable notice or you pay them in lieu of that reasonable notice. The termination of an employment contract itself, according to the Alberta court, is not a breach of contract. The only breach would be the failure to give adequate notice or pay. Now, there are situations in which, bad faith could have been made out in regards to a termination, but the court noted that in that case, the burden of proof would have been on the employee to prove that there was something improper about his termination, if that's what he believed. He would have had to show that it was bad faith. For example, they misled him, actively lied to him about the duration of his employment, and nefariously terminated him, and he would, likely have to prove that they did so in order to stop him from getting his bonus payments. So a quick review now, Paquet and Terrago networks. This is one of the Ontario Court of Appeal cases that came out in August of 2016, and it describes an approach to determining these issues that wasn't necessarily followed by the Alberta court in this case. So step one, according to the Ontario Court of Appeal, is to consider the employee's common law rights. Was the bonus an integral part of their compensation? If so, a common law right exists for that employee to receive damages in regards to that bonus during their notice period. Step two would be to consider the language of the plan or the contract. Only then do you ask, according to the Ontario Court of Appeal, is there language in that plan or contract that alters or removes the employee's common law right unambiguously? Now, this is where it gets sort of contentious. The Ontario Court of Appeal has said that, quote, a term that requires active employment when the bonus is paid without more is not sufficient to deprive an employee terminated without reasonable notice of claim for compensation for the bonus he or she would have received during the notice period. So on that analysis, the Alberta court, it's worth noting, seems to have sort of jumped past this first step in the test. You know, they don't sort of do a general consideration of the common law at play, and immediately considered whether the language in the plan was clear, unambiguous, etc. So a possible way to sort of harmonize the decisions is to note that in the Ontario cases, you know, the bonus, so say the bonus would have become vesting or payable during the notice period. So I believe in one of those two cases, the notice period was 17 months long. A bonus payment would have vested or become payable, let's say, you know, 10 months into that, for example. It's notable that in the Alberta case, the bonuses were vesting or becoming payable after 4 years. And in this case, that actually wasn't going to occur during the employee's reasonable notice period. So the vesting of the bonuses actually would have occurred at some point, you know, a year, 2 years, et cetera, in the future. And there's sort of a concurring result given by Justice Berger in the Alberta case. He concurs in the result, but again, gives his own reasons and seems to more specifically focus on the fact that the grants hadn't vested yet, and that was the key. They wouldn't have vested during the reasonable notice period. This sort of difference in the jurisprudence from the two provinces is a bit of a difference in attitude that the two courts take. For example, you know, in Ontario, the courts have said that, you know, you either, when you terminate someone without cause, you give them reasonable notice, or if you don't give them reasonable notice, you breach the contract, and the solution to that breach is to give them damages. So pay in lieu thereof is damages, according to the Ontario Court of Appeal. Sort of a theoretical point, but in Alberta, according to the Court of Appeal, paying someone in lieu of reasonable notice is actually not breaching the contract. It's fine to pay them, and that payment isn't damages. So if we sort of look at the language from the two cases, we kind of don't know for certain because the Alberta court doesn't specify. But again, the language on the slide here in front of me and the court's sort of general approach does seem to conflict with the Ontario decisions. Again, the bonus plans in Ontario used very similar languages, and that language was not found to be sufficient. So the Alberta court seems to be suggesting that, you know, even if those bonuses had vested during the notice period, the language of the contract would have rendered them unpayable, or they wouldn't have had to be accounted for in a damage award. So the overall takeaway from these decisions, you know, the terms of the bonus plan will be important for determining any bonus component of wrongful dismissal damages. So, you know, your language in your plans or in your contracts can contain eligibility criteria, establish formulas and conditions, and set the limits. However, it's notable, especially if you're in Ontario, it will be extremely difficult, in our opinion, to limit entitlement where bonus payments vest or become payable during the reasonable notice period, and that's part of the key, not at some point after the reasonable notice period is up. Best approach in this situation, it can get a bit complicated, is to consult with employment counsel when you're drafting a bonus plan or contract. So, you know, in the first instance, be preemptive, but consult again when you're thinking about terminating employees to see how the sort of chips are likely to fall. As a general rule, the courts have said, you know, it's important to make sure that any limitations in the contract or plan are brought to the affected employee's attention, and that these bonus plans form part of their contract of employment, so are recognized as such. There's a bit of hope, you know, just a quick 2 seconds about a case from the Divisional Court in Ontario that came out after those Court of Appeal decisions. And in that case, the language of the plan indicated that the bonus was completely discretionary. So the employer was actually able to make out that the employee's performance, you know, it wasn't bad enough to terminate him for cause. It wouldn't have risen to that standard, but the employer still wanted him gone because he just wasn't doing very well. You know, they gave him pay in lieu of notice, terminated him without cause, and they were actually able to illustrate to the court that a bonus wouldn't have been paid to him even if he'd been allowed to work out his notice because his performance was simply subpar. So that's the benefit rather of sort of having discretionary language in your bonus plan. The overall takeaway, again, due to these sort of complicated provisions, is to consult with a lawyer before taking any action.